With the consent of other side, Lordship, I wish to mention item number 8. Here, Lordship, item number 8, Lordship. Here, Lordship, I have not received the record because the executive officer of Tinsukia Municipal is on leave, Lordship. So I pray for some time, Lordship. Let it be on after he is joining by first week of December. So second week I've taken the consent. And as per my instruction, Lordship, the meeting was held on 28/7/22.
That day I heard the matter.
Yes,
What leaves remain?
Lordship, Lordship has asked for the meeting held on whether the committee was constituted and the meeting was held on where approval. The meeting was held on 28/7/2022, but I don't have the record, Lordship, because the executive officer is on leave.
We're getting the meeting from minus from where?
From the executive officer, Lordship, Tinsukia Municipal. He is on leave, Lordship.
When? We've not been able to obtain the instructions.
Instruction I have obtained, Lordship, that it was held on 28/7/2022, but the records, Lordship,
21.
second week of December, Lordship. Second week of December.
Why?
He is joining on first week of December, Lordship.
Is the Tinsukia Municipal Board not functioning?
He's functioning, but the record, Lordship.
He had taken it with him where he's gone.
No, Lordship, he not with him, but in his custody. I have told my Lord.
So there's no in charge of the executive officer during this period. No, let me understand. Is there no executive officer or no person who has been in charge? Means therefore I'm saying whether the Tinsukia Municipal Board is functioning or not. How? Because he's the main.
Lordship.
So if he must have given the charge to somebody.
This is the letter, Lordship, I have received, Lordship, from the chairman, Lordship, that he is joining in the first week of. The meeting was held in the DC office,
Who is the chairman?
Lordship.
Who is the chairman
Pulak Chetian.
of the board? The executive officer leaves, it has nothing, I mean, he cannot produce. So we presume that there's no documents.
There was
No documents. We presume it in that manner, there's no documents. If this is the reason, isn't it a very vague letter to be produced before a court? Isn't it very vague? Or is it the chairman thinks it is above the court?
no, Lordship.
If we think so, it's a different thing. We'll take it up in that manner.
Please, Lordship, my Lord, I pay for
Mr. Siggar,
this matter.
I am dealing with another matter. If he takes it in this manner, I don't have the problem. But the fact remains what I have asked it. The letter doesn't inspire the confidence. He thinks that he says that as the executive officer is not there, so he will join, so we'll give it. Is this how the Tinsukia Municipal Board functions?
No, Lordship. That it briefs, Lordship, that due to some.
Is this the language used?
Lordship. It is to be me, Lordship. That's why for asking I wanted some written communication, otherwise. That's why, Lordship.
Okay, you file an affidavit on behalf of the chairman that there is no person who has any in charge of this, who has no custody of the documents if the executive officer is not there. It's just an executive officer. Then doesn't the board have the control? Can the executive officer do anything without the presence of the board? This court, by an order dated 3/11/2025, had raised various queries upon the Standing Council of the Tinsukia Municipal Board as regards the compliance to various provisions of the Assam Municipal Act 1956. On the said date, the learned counsel appearing on behalf of the Tinsukia Municipal Board sought for time for obtaining instructions. Today, when the matter is being taken up, it has been submitted that the executive officer is on leave. And as such, the chairman has instructed him to inform the court that without the executive officer, none of the records can be produced. So that the instructions which have been sought for can be apprised to this court. Taking into account the above, this court fixes this matter on 9th of December 2025 at 2 p.m. The Tinsukia Municipal Board is directed to bring on record their stand in respect to the queries made by this court by the order dated 3/11/2025, as well as also produce the records. If no records are produced, presumption will be drawn that such records do not exist. List accordingly. Yes, Mr.
Paying
Sikka.
for listing the matter on the next Monday matter released to Gapura appointment. We are against the order of TLR, Director of DLR.
Motion
Motion.
tomorrow?
Normal, on Monday.
His lordship, WPC for order.
For last 3 days, you have been troubling me, always mentioning, and I don't get a head and tail of what you say. So again, tell me what has happened. Yesterday also you mentioned, day before also you have mentioned. Yes, what is it?
This matter are related to Panchayat. This matter related to Panchayat case. WPC for
Put the mic down a bit so that we can hear you properly. Mic down. This, yes. Now tell me.
Sir, lordship, this matter are related to Panchayat case. So kindly list the matter for order.
Panchayat for what?
This petitioner are convicted for election rule. um, This petitioner are convicted from election rule.
Convicted. You need to prepare further. Again, mention the matter on Monday. You are there.
Unlisted master matter. The urgent matter, site visit certificate matter, last day matter 11, they have already submitted to the site visit certificate matter. And today matter, two matter.
Site verification.
Matter.
Tomorrow?
And tomorrow your lordship is not sitting probably.
I am not there, whereas somebody else will be there.
Matter, 11 was last
Board
day matter.
functions always, whether I am there or not.
Finally, Tuesday matter.
Okay, 2 p.m.
Time of the. Wait, please, your lordship. The lordship, I'm praying for listing of a matter today. Potential disconnection of electricity.
Motion? Okay.
Oblige, Lord.
So I'll rise early, 3:15 I'm rising. So get it before that if you want the order.
Yes, oblige.
We'll see. Electricity, we have to give importance.
Lordship, I have to mention for listing the matter for admission.
Admission? When? What is the matter about?
Matter electrification,
Huh?
short circuit,
What?
electrification.
Electricity.
Electrocution. The-
Electrocution,
Yes, yes,
death.
that.
Isn't that bench 5 matter?
The bench, 4 matter.
Is it? The bench 5 matter. This compensation business, I have no business. You go there.
Okay.
Item 1 for delivery of orders and further hearing.
এই আপুনি ক'ত মাৰিছিল নহয় আধা আছিল মোক দিছিল বেলেগকে আছো which one ৰিপ্লাইও ক'লো এতিয়া submission লম
Lordship, for Lordship starts dictating.
let us take I'll take your submission also
No,
I'll
just
take
went
her
through
submission
The judgment of this, Calcutta Court, High Court, Your Lordship. I went through a judgment. Thereby it says that
I'll don't worry I'll take your okay let me first
for Your Lordship.
take her submission and record her submission then I'll record your submission of whatever you want to say if you want say less that also I'll incorporate don't worry and then my decision Madam Hazarika, there are three aspects. First, I have to take care of the impugn order,
Yes.
whereby it has been rejected. Impugn order is drawn up on three lines, three aspects. First, there is already there's a memorandum of understanding. Second, it is not mentioned. It could not be ascertained as to whether you are an MSME. Third, whether they informed you, whether you informed that you are an MSME. These are the three for which they have exercised. Now your submissions would be as regards the memorandum of understanding that cannot override the principle of law. Apart from that, you have also alleged coercion. Secondly, you say that whether you are an MS, the moment you are an MSME, which they duly admit in all other documents,
including the memorandum.
including the memorandum, they have admitted that you are an MSME. One. Secondly, it is their very case out here to say that if they go to the MSME, then they will get some facilities for conciliation and all these things. And therefore, MSME is the tribunal is the best option. So the moment they say that, they are again, it is
Admitting that
admitted
I'm-
by them that it is an MSME.
Absolutely.
When they say that that is the tribunal, because MSME tribunal can only take into account MSME in view of the judgment of Justice M.R. Shah.
Yes.
That's your second. The third is, whether you inform or not, that is immaterial. The fact that you are an MSME, if it is proved, which they duly admit, by operation of law, you get it.
Right.
That's your three submissions.
And as far as the going to conciliation is concerned, apart from the fact that if I'm a MSME only, I can go. But in this writ, what I'm praying for, please implement the act.
Okay.
I am not disputing the interest. I am not calculating the interest. I'm giving it to their good judgment and conscience.
No, it cannot be. There is a reason why I'm saying that. There has an importance. My A private secretary have asked one of your persons to give me the details as regard the chart, because in respect to one of the items, there is a chart being given in paragraph number 13,
Yes.
which I have taken. In the second and third also, he has provided the
given.
chart, which has now been incorporated in this half-made judgment. But if we take section 16,
Yes.
and therefore I brought in the judgment of the Calcutta High Court,
Yes.
it stipulates how the calculation will be made.
Yes.
Your basic case is here that kindly implement section 16.
Yes.
So this court can pass an order to the effect that kindly give them interest as per section 16.
Yes.
What would be the amount is absolutely between, you have to mention, because section 16 has two aspects. First, if there is nothing mentioned, it can't be, it will be date 15 days,
Yes.
no mention. But if there is something mentioned, then it cannot go beyond 45 days. That is the mandatory law. The details which you have furnished out here do not show when you have supplied. So there has to be a calculation to be made on your side after I pass that order
Yes.
and give it to them. That this is the date on you which you have accepted, and the interest would be accordingly taken there. There is further another thing, taking into account the current RBI rate. There will be a further quantification taking into account the RBI circulars
Yes.
as to what is the rate. Because what is the main aspect is, it's a very troublesome calculation, which when Mr. Bhattakur told me, I didn't think it is so, sir. But maybe it may be easy with nowadays the different types of calculators.
the
They can
applications.
do it with that particular interest out there. But it is being compounded every month.
Every month.
So just for example, for month of January, February, March, the interest of the RBI remains at 6%, because the RBI interest is different from the interest of the state bank. So they do it on the basis of certain basic points. So the RBI interest, let us take the example of a 6%. It would be 18%. But for the month of April, the RBI enhances the rate to 6.5. Then it will be 18.5 or 19%. So 19% would be the interest on which you have to make the calculation. So these are the calculations which I propose that you have to pass. I'll pass the order. Then the calculation goes to them. If there is a dispute thereupon, as regards you are an MSCB is a fact which I'll declare. This order has to be set aside. But the fact that if there is a dispute thereafter on the calculation, it is the MSME who will look into it.
Lordship, up to 2019, the calculations.
No. That I'm not going to go, because that has gone for a 6. As regards, because you are asking for implementation of section 16. I will give you the whatever section 16, but the calculation has to be made to them. And if they don't do it, then it will keep on running. And this payment of whatever payment will be taken. Did you get Gurpreet Singh? Gurpreet? Ah.
And I got another case from of the Privy Council.
Ah.
Very clear. Just one page judgment.
Yes. Section 16, huh?
Yes, on apportionment of interest.
Section 60, they say
Okay,
about,
yes.
because section 60 is the main provision, Contract Act, how the apportionment will happen.
Yes.
Now, if the court declares, why I ask you to take Gurpreet Singh, there's a reason why. Gurpreet Singh also takes care of that during the interim, if the court directs 50% payment,
Yes.
then how will you do it?
Apportion is correct.
Whether it would be, then the Supreme Court, the Constitution bench says that no, then also it cannot be taken as the court directing them to pay that or appropriating in that manner.
Yes,
Isn't
it
that
goes to
paragraph
interest
some?
first. Correct. It goes to the
And Gurpreet.
even Privy Council has given a very nice judgment on that.
Yeah, very good. Give it to me, Privy Council. Yes, what do you have to say?
That's the issue I was pointing out, Lordship.
So therefore, Your plan is for sending to the MSCB. That's your lookout. But that is at your peril. But I'll make it very clear on that aspect. Where is that provision? Which paragraph, madam, you're reading?
Lordship, third page, last paragraph.
Hmm?
The third page, last paragraph. The question then remains as to how, apart from any specific apportion, these sums ought to be dealt with. There is debt due that carries interest. Therefore, there are money that are received without a definite apportioning on the one side, and on the other side, and the rules which is well established in ordinary case is that in these circumstances money is first applicable in payment of interest, and then when there is a satisfaction of payment of the capital, the rule is referred to by the law this benefits.
No, this is known. That is in fact section 60 of the
Good,
Contract
Pritchett.
Act. Now, therefore, the thing is like this. Why I asked you Gurpreet Singh is this.
I've got good.
There are three aspects. First, it will be apportioned against interest, then cost, then the principal.
Yes.
Now, if in a case where the court directs in a decree, I think there is a specific paragraph on that aspect. If the court directs in a decree that you see, whatever amount is being paid shall be first apportioned towards the principal, and then remaining, then the interest will be taken care of. Then it is a different aspect to the matter. But otherwise, the rule is first interest, cost, and then yeah.
Yes, Lordship, in 1969 Supreme Court says that.
So just give me Gurpreet Singh, I'll show you that.
Good. It will read, yeah, no? आपके पास और good picture, our good picture. Here. This one is good picture, no? Yeah, big one. Booking नहीं ले रहा. Booking नहीं ले रहा. Booking लेगा तो
Yes, paragraph 11.
yes.
The relevant provisions governing contractual dealings are found in section 59 to 61 of the Contract Act. According to Suento, the underlying principle is that where the several debts are due and owing to one person, any payment made by the debtor either with an express intimation or under circumstances from which an intimation may be applied to the discharge of the debt in the manner intimated, or which can be applied from the circumstances. Then the rule of apportionment as applied in India was summed up in so and so in the full bench decision of the Madras High Court. It has to be noted that section 59 get attracted only when more than one debt is due from the debtor to the creditor. The section would not be attracted where there is only one debt due, nor have they any direct application in a case where the debt due has merged in a decree. And the applicable rule then would be what is provided in the decree itself, or the general rule applicable in execution of money decree. Now kindly come to paragraph 14, 15. Provides that the mode of paying under a decree, it stipulates that all money payable under a decree shall be paid by the deposit into the court whose duty it is to execute the decree, or out of the court to the decree holder in the manner provided, or otherwise as the court which made the decree directs, subrule 2 so and so, only on an amount paid by way of deposit into the court or as directed under the decree interest, if any shall cease to run from the date of service of so and so. Even the amendment is made. Paragraph 20. In so and so, this court considered the question whether section 59 of so and so would apply to a debt that has merged in a decree. This court held that section 59 and 60 of the Contract Act would be applicable only at a pre-decretal stage and not thereafter, since post-decretal payment are to be made either in terms of a decree or in terms of the agreement arrived at between the parties. Though on general principles as mentioned in section 59 and 60 of the contract, it was also held that the general rule of appropriation towards a decretal amount was that such an amount was to be adjusted strictly in accordance with the directions contained in the decree, and in absence of such direction, adjustment be made firstly in payment of interest and cost, and thereafter in payment of the principal amount, subject of course to any agreement between the parties. Now there is no agreement to that effect. There is no decree today. So therefore it will be regulated by 59 and 60.
60.
Now that is one. Then if you see this particular paragraph, yes, 52. What is to happen when a part of the amount awarded by the reference court or by the appellate court is deposited pursuant to an interim order of the appellate court or the further appellate court, and the awardee is given the liberty to withdraw the same? In such a case, the amount will be received by the decree holder on the strength of an interim order, and the appropriation will be subject to the decision in the appeal or the further appeal and the direction, if any, contained therein. In such a case, if the appeal is disposed of in his favor, the decree holder would be entitled to appropriate the amount already received by him pursuant to the interim order, first towards interest,
Yes.
then towards cost, and the balance towards the principal as on the date of withdrawal of the amount, and claim interest on the balance amount of the enhanced compensation by leaving execution.
'53 also says the same thing.
Yeah. So these 59 and 60 shall continue till, as they say,
Yes.
till the decision of the MSME. So that apportionment cannot happen till then.
Suppose they agree and pay, save the interest.
Huh?
They can agree and pay.
That's a different thing. They agree
It's
and
good-
pay.
Good
If they agree and pay, it's well. But if they don't pay, this is what is happening. So, but that will happen like that. Because I have to take care of that also, because this court directed them to make the payment of whatever they have admitted.
Yes.
But this is an interim, so this have to be
This will
brought in.
be adjusted towards the interest.
Because otherwise your interest gets arrested from the
Yes.
date they have received the payment.
The 69 Supreme Court also says the same.
Hmm?
69 to SCC also says.
Mm. No, this is, I was more concerned about this paragraph 52.
Yes.
But I remember that paragraph, so therefore I directed. Otherwise, there has a lot of implication on that. If you are just direct any they pay, this will have a far-reaching consequences later. Okay. Miss M. Hazarika, the learned senior counsel appearing on behalf of the petitioners in the batch of writ petition. Submitted that the speaking orders, which have been assailed in the three writ petitions, all dated 27/4/2023, cannot be sustained in law inasmuch as the reasons assigned in the said order is contrary to the principles of law, settled principles of law, as well as the provisions of the Act of 2006. The learned senior counsel submitted that the reasons assigned in the impugned order dated 27/4/2023 are threefold. First, that there is a memorandum of understanding dated 14/5/2019 which on a malicious reading by the respondents had taken a stand that the petitioner is not entitled to additional interest. The learned senior counsel further submitted that the second ground is, however, contrary. The second reason so assigned is, however, contrary to the first reason, inasmuch as in the second reason it has been stated that whether the petitioner could not be known whether the petitioner had a valid MSME registration certificate, though relying upon the memorandum of understanding dated 14/5/2019, though the respondents, though in the memorandum of understanding dated 14/5/2019, it is duly admitted by the respondent department that the petitioner is a MSME. The third reason so assigned also is contrary to the settled principles of law. Inasmuch as the respondent authorities have come to have assigned the reason that the petitioner did not disclose its status as an MSME entity whilst the said work was allotted. The learned senior counsel submitted that the Act of 2006 provides benefits to the MSME, medium, small, to the micro,
MSMEP.
to the micro, media, small, medium, MSM enterprises. For the purpose of encouragement of these MSM enterprises, the learned senior counsel further submitted when a contract had been awarded when the work orders in question did not, where the tenders as well as the work orders did not debar the participation of MSE enterprises, and the work orders have been issued thereupon, the extent law had to be applied. Which is the Act of 2006, and more particularly, Section 16, which stipulates, or Section 15 and 16, which stipulates as to when such payment is required to be made. Anything else?
Lordship, it was the policy of the government to award only to MSME. So now, it was the policy of the government to give the work orders only to MSME.
Is it there?
Right from APSC Act. So these could not have been given to non-MSMEs. Now they cannot question.
Okay. It was also submitted that in terms with
Assam preferential stores procedure.
the Assam Preferential
Stores procedure.
Stores Purchase Act 1989,
And thereafter the procurement policy under the MSME.
as well as the Assam Procurement Policy 2015,
15. 15.
15,
One.
which was made under the aegis of the Act of 2006. It was the very policy of the government to encourage and give contracts to the MSMEs. And therefore, the respondents now cannot question the same. Additionally, the learned senior counsels further submitted that from the various pleadings in the contempt applications, connected contempt applications, as well as in the present proceedings also, the respondents have duly admitted that the petitioner is an MSA, comes within the ambit of the Act of 2006. And just for the purpose of depriving the petitioner of the benefits under the Act of 2006, the respondents cannot be allowed to act in the manner in which the impugned order has been passed. The learned senior counsel submits the details have been given in the writ petition that the respondent authorities have picked and chosen some contractors and given benefits under the Act of 2006. But similarly situated contractors like the petitioner have been deprived for reasons best known. The learned senior counsel further submitted that during the pendency of the present proceedings, certain payments, the admitted amount have been paid. That too when orders were passed by this court. But as those orders passed by this court did not specify as regards how the apportionment is to be carried out, the said amount so paid has to be adjusted against the entitled interest first. Thereupon, if any costs factor is involved, and then the principal can be touched. In that regard, the learned senior counsel referred to the judgments of the Supreme Court of the Privy Council in the case of Mecca Venkatra Appa, नाम तो लिख दियो, बहुत लंबा नाम. Reported in 2014 Law Weekly, page 25. Then Meghraj and others versus Bayabai and others reported in 1969 to SCC 274. And the Constitution Bench judgment of the Supreme Court in the case of Gurpreet Singh versus Union of India reported in 2006 8 SCC 457. In addition to that, the learned senior counsel also submitted that in the very affidavit in opposition, so filed by the respondents, that they have taken a categorical stand that the present proceedings ought not to be entertained, taking into account that there is an alternative and efficacious remedy available before the MSME Facilitation Center in terms with Section 18 of the Act of 2006. Which judgment I said? Ah. Where is the Justice M.R. Shah's judgment? That day I gave, na?
Yes. MSB will over there. Now, so, Doctor, 2025 Supreme Court online
2000?
25
No. That is just Narasimha's judgment.
Yes.
I'm
That's
saying
MS
about Justice M.R. Shah's judgment. I gave you, na, 2018 5. Huh?
It's 221.
2024. 12 SCC. Do you have the copy of it? No.
No, I
I'll just,
What is the name?
Nitesh Estates versus MSME Council of Haryana.
Nitesh.
Nitesh, N-I-T-E-S-A. States.
Nitesh.
Estates.
Huh?
E-S-T-A-T-E-S versus
Estates.
Estates versus MSME Council of Haryana. Most probably para 6 will come in.
Nitesh Estates Limited versus MSEFC Haryana reported in 2012 24 12 SCC page 221.
this one. Repeat, I don't know. Verify.
Wherein it has been specifically mentioned that the facilitation center council, the micro and small enterprises facilitation council, can only adjudicate dispute between a supplier
and the buyer.
who is an MSME with in respect to a contract where the supplier is an MSME. The learned senior counsel therefore submits that the very stand of the respondents categorically therefore admits that the petitioner is a micro MSME coming under the Act of 2006. Per contra, Mr. R.R. Gogoi, the learned counsel appearing on behalf of the PhD department, submits that a memorandum of understanding was entered into by and between the petitioner and the respondents and the respondent PhD department in all the three writ petitions. In view of the said memorandum of understanding, the respondents cannot be settled with any further liability than what has been agreed upon by and between the parties. He therefore submitted that the impugn order by which the further liability of interest in terms with the Act of 2006 have been rejected do not call for any interference in view of the agreement by and between the petitioners in the batch of writ petition with the respondent PHE. He further submitted that whether the petitioner is an MSME at that relevant point of time could not be ascertained during the verification. And therefore, the question of making payment for the period when the work orders were issued at the rates stipulated in the MSME Act and the Act of 2006 cannot be decided in such a manner. Additionally, the learned counsel submitted that the reason that another very important aspect is as to whether the petition respondents can be saddled with any liability if the petitioner does not inform that it is an MSE. It's a small micro or a small industry coming under the Act of 2006. It is only at best, it is only from the date such information has been provided, the respondents could be made liable. He therefore submits that the reasons so assigned in the impugn order dated 27/3/2025, 27/4/2023 do not call for any interference. Additionally, the learned counsel submitted that these aspects can be very well decided by the MSME Facilitation Center in terms with Section 18, wherein not only there is an arbitration proceedings which can go on between the parties, but prior to that, there is also a conciliation proceedings whereby opportunity, the petitioner, there is also a mediation proceedings by which the respondents can mediate as regards so that the amount can be reduced. The learned counsel further submits that this facilitation center could have been very well approached by the petitioners rather than approaching this court under Article 2 to 6 of the Constitution. Anything more?
Lordship, at section 18, reference to micro and small enterprise facilitating council, notwithstanding anything contained in any other law for a time being in force, any party to dispute may with regard to amount under section 17 make a reference to micro small and enterprise facilitating council. Here, any party, which even the respondent can also go, if we dispute, or the petitioner can go. That's and the further the work order.
But you wanted to go long time back, you have not gone.
But the work order, Lordship, work order, they say it's for only for MSME. The work order doesn't contain that particular clause that this work order is only for the MSME allowed. The work order which a petitioner take it, that is only for the MSME to execute. The work order which they have annexed here, that doesn't say anything about the MSME, that this work order is only for the MSME.
The learned counsel for the PhD department further referring to the work orders enclosed to the writ petition submits that these work orders do not mention that such work orders are, that the work orders are to be only issued to the MSME. Anything more?
No, Lordship. And the judgment of this Calcutta High Court, or judgment of the Calcutta High Court, where the variables are taken.
Let me leave something for me.
Yes, sure.
Okay. Analysis and determination. Upon hearing the learned counsels appearing on behalf of the parties, this court, the primary question which arises is as to whether the petitioners herein in the batch of writ petitions in the present facts would be entitled to claim benefit of section 15, 16 and 17 of the Act of 2006. As submitted by the learned senior counsel, a perusal of the impugned orders dated 27/4/2023 in all the three writ petitions provides three reasons why the petitioners have been deprived. The three reasons are: number one, the petitioners in the present batch of writ petition had entered into a memorandum of understanding dated 14/5/2019 and as such not entitled to any additional interest. Number two, it could not be ascertained whether the petitioner in each of the writ petitions was in possession of a valid MSME registration certificate as required under the Act of 2006 at the time when the work order was awarded and executed by it. Number three, it could not be ascertained if the petitioners in the instant batch of writ petition have duly disclosed its status as MSME entity whilst the said work was allotted. Under such circumstances, this court, therefore, would be taking each of the reasons assigned taking it on the basis of the materials available on the record, as well as the respective submissions so made by the learned counsels appearing on behalf of the parties, as to whether such reasons are justified to deny the petitioners the benefit under section 15, 16, and 17 of the Act of 2006. Let this court now first take up the first reason about entering into a memorandum of understanding dated 14/5/2019. In the previous segments of the present judgment, this court have duly quoted the memorandum of understandings which have been entered into on 14/5/2019 against each of the petitioners of the present writ petitions. Hey, बाकी फाइल की तो देख. Where is that memorandum of understanding in that first one?
One second.
And Garg?
Page 109.
Perusal of the Pustak. Before taking up each of the memorandum of understanding entered into between the petitioners, it is relevant to take note of that the schemes under which the work orders were issued upon the petitioners. Admittedly, these work orders were issued under the schemes of the central government.
Some central government and some state. The memorandum is in respect of the central government.
Now, that is what I am saying.
Yes,
Because there is some amount here, if you see that particular document,
yes, that is the state.
where is that? They have given that here, no? This 2 lakhs something they are saying. Yes.
Memorandum is central government.
Huh?
Memorandum is central government.
Yeah, that I have seen. That I have to clarify, no?
Yeah.
Otherwise, the division bench will say this, look here, this judge didn't look into anything.
State.
Huh?
Lordship,
There is one document where it is seen somewhere that they say that 42 lakhs and 62 lakhs here. In this case,
page 159.
in some affidavit filed by the chief engineer, he has
Yes,
enclosed
Lordship,
that.
159, that affidavit which is
Page
page 159.
150.
Next to the affidavit filed by this.
Ah, this one. This one.
159.
But here in this case, it appears that it was it was both the persons, this is, which is being stated out here is a scheme of the central government where some portion is to be paid by the central government, some by the state.
Yes.
Because
Yes.
this seems to be the accumulation in that manner.
Yes, yes.
And NDRP Anganwadi. लिख लेते last line too. No, so there are various work orders which have been issued. As have been already also detailed out here in above. Some work orders pertains to a combination of a scheme of the state government with the central government, and some pertains to purely state government schemes. In the affidavit filed by the Chief Engineer Public Health Engineering in content case number 101/2019, a detailed statement of a court case against the court case of the petitioner have been mentioned, have been enclosed as Annexure A to the said affidavit. From the said statement, it is seen rupees 44,42,703 have been earmarked as the amount payable under the head of NRDWP. Bracket, what is the name, full name?
National Rural Drinking Water Project.
National
National Rural Drinking Water Project.
Drinking Water Project. Bracket of TTO.
Oh, sorry, program analogy, program, no.
And rupees 62,33,618 is shown as the principal from the state sector oblique fund. In the backdrop of the above, if this court now takes the memorandum of understanding, page 109, no? 100
109.
understand. What is referred to insofar as the case of the petitioner in WPC number 4631/2023 is only in respect to the amount of rupees 42,56,645 under the NRDWP head. And there is no mention whatsoever in the said memorandum of understanding in respect to the payment to be made from the state sector oblique fund, which was rupees 62,633,618. The present case, which have been filed by the petitioner herein, that is WPC number 4631 oblique 2023, is for claiming interest, is claiming the amount of rupees 62,33,618 along with interest in terms with section 16 and 17 of the Act of 2006. Under such circumstances, it is difficult for this court to even conceive as to how the memorandum of understanding dated 14/5/2019 would have any application towards the claim of the petitioner in respect to the amounts due from the state sector oblique fund. Next one. Next, second one, SRK methods. Well, I know. SRK methods.
Memorandum is page
5273.
94, right? The memorandum is page 94.
Page 90.
4.
In respect to the writ petition pertaining to WPC number 75273 oblique 2023, the memorandum of understanding was also entered into on 14/5/2015
19.
or 19, the details of which the say 19, which have been already quoted here in about in the previous segments of the incident judgment. Where is that affidavit? That
Affidavit document at page 96.
page?
96, and the annexure, relevant annexure is at page annexure.
Ah.
98, 99, 9900, 99.
90. In the affidavit filed by the Chief Engineer Public Health Engineering Department, it has been categorically mentioned in contempt case number 517 oblique 2018, it was categorically mentioned that the dues in respect to the petitioner were under two heads. An amount of rupees 58,63,470 was on account of funds under the NRDWP head, and in respect to the state sector oblique fund, the amount payable was 32,44,879. It is also seen that an amount of rupees 154,53,588 was shown as interest already paid, which was calculated up to 31st of March 2019 under the NRDWP, and an amount of rupees 225,24,232 was the interest payable which will be under the head of the state sector, isn't it?
This I don't know, Lordship, total interest if calculated. So part of the interest they paid, 1 lakh.
No, there are two. Already paid is 154
Yes.
and to be paid is 225.
Yes.
Means the total amount comes to around more than 3 crores.
Yes.
In the backdrop of the above, let this court now take note of the for memorandum of understanding entered with the petitioner in WPC number 5273/2023. Wherein it is duly mentioned that the final principal amount payable to the petitioner was rupees 48,58,246 as on 14/5/2019 under the head NRDWP. And further, there would be an amount paid calculated up to 31st of March 2019 towards the interest. A very perusal of the said memorandum of understanding do not show that this memorandum of understanding have any nexus or relation in respect to the dues payable from the state sector of the fund, which is rupees 32,44,879 along with their interest. It is further seen that at clause B of the said memorandum of understanding, that the payment which was to be agreed to be made of the principal due as well as the interest was only in respect to the NRDWP head. And there was also mentioned that there shall be no interest under the NRDWP head beyond 31/3/2019. The present application, the claim in the presently, which is in issue, is not in respect to the amounts payable to the petitioner under the NRDWP head, but on account of non-payment of the dues which was under the state sector head, which was rupees 32,44,879 as the principal. Third one.
Page 92, Lord.
Page
90.
in WPC number 5966/2023, the memorandum of understanding dated 14/5/2019 have also been quoted here in the previous segments of the instant judgment. A perusal of the same memorandum of understanding stipulate that the final principal amount under the NRDWP head, which covers O&M head 2 of rupees 142,124.37, 37. There's some mistake somewhere. 1,42,124 zero at
Yes.
zero at a month.
The written part is correct.
1,42,124 124 and 37 paisa was due for payment as on 14/5/2019 under the head NRDWP. And it was agreed to that the said amount, principal along with interest up to 31/3/2019 would be paid. Now coming to the affidavit which was filed by the chief engineer in contempt case number. Where is that?
Content case number 139.
130, 103,
10?
Page number 139.
page number 139, contempt case number 103. Page 139.
Page 10?
139,
139.
139.
contempt case number 103.
In the affidavit so filed by the chief engineer in contempt case number 103/2019, it is categorically mentioned that the principal amount payable under the NRDWP head was rupees 142,31,062. And from the state sector oblique fund was rupees 24,53,013. And the interest to be payable was rupees 788,87,069. Calculated up to 30th of November 2020. In the instant case, the petitioner herein have only claimed the amount for the state sector from the state sector entitlement, that is rupees 24,53,013, along with the applicable interest in terms with section 15, 16, and 17 of the Act of 2006. So, under such circumstances, it is very difficult. It is totally misconceived on the part of the respondent authority to reject the claim of the petitioners by the impugn orders on the ground that the petitioners have entered into an MOU, Memorandum of Understanding, on 14/5/19. At the cost of repetition, this court further observes that those Memorandum of Understandings dated 14/5/2019 entered into by the petitioner respondents with the three petitioners in the present batch of petitions were only in respect to NRDWP and not in respect to the state sector oblique fund. Before proceeding to the next ground, this court further finds it very relevant to take note of an important aspect of the matter. That is, that in all the three Memorandum of Understanding, the respondent authorities categorically admitted that the petitioners were micro, small, medium enterprises were duly incorporated under the Micro, Small, Medium Enterprises Development Act 2006. Let this court now proceed to the second ground, reasons to assign. Let me come back. The second reason so assigned is on the ground that is that it could not be ascertained whether the petitioners in the present batch of writ petitions were in possession of a valid MSME registration certificate. It is surprising to note that on one hand, the respondents have all along duly admitted that the petitioners are MSMEs. The petitioners are duly registered under the Act of 2006 and entitled to interest, as would be seen from the pleadings of the respondents. The officials of the respondent in the various contempt cases. Even in the Memorandum of Understandings dated 14/5/2019, on which reliance have been placed by the respondent authority in passing the impugned order dated 27/4/2023. There is a clear acknowledgement that the petitioners are registered under the Act of 2023, 2006. Be it as it may, this court, while detailing out the facts in each of the writ petitions herein above, mentions the various dates on which the petitioner was registered. Petitioners were registered under the Assam Preferential Store Purchase Act 1989, as well as when the petitioners were issued Entrepreneur Memorandum Part 2 in the additional affidavits which were filed in all the three writ petitions. By the petitioners, the notification dated 29/9/2006 issued by the Ministry of Small Scale Industries have been enclosed. This notification was issued in exercise of the powers under Section 8(2) of the Act of 2006. Schedule 2 to the said notification stipulates the procedure of filing the entrepreneur memorandum and other matters incidental thereto. This memorandum, this application can be filed by any person who intends to establish a micro or a small enterprise at his discretion, or a medium enterprise engaged in providing or rendering of service may at his discretion, or a medium enterprise engaged in manufacture or production of a goods shall file the memorandum of micro, small, or as the case may be, of medium enterprise with the district industry center of the area. It is further mandated that the district industry center shall fill all the codes in the form of memorandum and issue an acknowledgement after allotting an entrepreneur memorandum number, date of issue, and the category of the unit within 5 days of the receipt of the form of memorandum by post, or same day if the form of memorandum is submitted in person as well as online. It is further mentioned that the district industry centers shall maintain records of all the entrepreneur memorandums so filed in respect of micro, small, and medium enterprises engaged in providing and rendering service. And the district industry centers shall also forward a copy of the entrepreneur memorandum so filed with the entrepreneur memorandum number allotted to the small industry service center institutes of the state or their jurisdiction. Clause 6, 7, and 8 of Schedule 2 of the said notification is relevant, and the same is reproduced herein under page 343. এখনত পাব, হা? কামাখ্যাখনত। From a perusal of the above 3 clauses, it is apparent that a memorandum shall be in 2 parts. The first part is to be filled up by the person and filed before the district industry center. And the second part, and once the said enterprise starts production or starts providing or rendering service, they shall file part 2 of the entrepreneur memorandum to the district industry center. First. In the case of the writ petitioner in WPC number 4631/2023, The petitioner, the said petitioner, initially filed the part 1, and thereupon the entrepreneur part 2 was issued on 1/3/2014. এইখন writ petition ক'ত হে? Where is that the document?
Lordship, page 57
Huh?
of EM
Writ petition? Ah, got it.
page 57.
A perusal of Annexure 4 to the writ petition would show the Entrepreneur Memorandum Part 2 issued by the General Manager District Industry Center categorizing the petitioner as a small enterprise. Additionally, the Entrepreneur Memorandum number was also provided. That is 180612011986. Where is that? After the Udhyam, you have done this, na? There's another certificate you have enclosed here.
Yes,
Yes, where is that document?
Udhar, Udham.
Ah.
Page 295 Udham.
Mrs. Hazarika, you have now understood why I'm dictating.
295.
Otherwise, the entire trouble I would have I had to take in my chamber.
No, it's too bulky, Lordship.
Huh?
It's too bulky. Udham is at page 30.
Where is
Sorry,
that?
295. 295 annexure 30.
MSME. There's an amendment by which it is now required, no?
Yes, yes, sir.
Where is that? Section 8.
By notification number dated 26/6/2020. This is it.
Where is that?
I'll just
Where do you get it?
I'm getting here in case graduation upward, its status
Page?
on the certificate only at the bottom it's there. Udham, date of Udham registration. It's available as per the provisions of notification. At the bottom, the benefit of government
No.
notification.
No, there is a notification which says now you have to
Yes.
get yourself registered by putting your Aadhaar, something like that. Yes, you see, Udyog Aadhaar Memorandum.
Yes.
So this number has to be given. So this is a notification, if I'm not wrong. I did one matter pertaining to
Notification for Udham Ahar. Where Aadhaar kahan hai? Aadhaar? It says that. No, Udham Aadhaar. I'll just get.
I got it.
There's the notification in July,
No, it is a notification I've got.
6th August.
It is very relevant to take note of. That a notification bearing number SO 2119 bracket E dated 26/6/2020 was issued by the Government of India, Ministry of Micro, Small, Medium Enterprise in exercise of the powers under subsection 1, read with subsection 9 of section 7 and subsection 2, read with subsection 3 of section 8 of the Act of 2006, whereby in supersession of all other notifications, including the notification referred to herein above dated 5/10/2006, certain criteria for classifying the enterprise as micro, small, medium enterprise and specified the form and procedure for filling the memorandum with effect from the first day of July 2020. Clause 7 of the said notification referred to the registration of the existing enterprises. The said clause 7 being relevant is reproduced herein under. From a perusal of the said quoted clause, it is seen that all existing enterprises registered under the EM Part 2 or UAM shall register again on the Udhyam registration portal on or after the first day of July 2020. And all enterprises registered till 30th of June 2020 shall be reclassified in accordance with the notification. There was also a fixed limit period stipulated that the existing Right. in terms with the said notification, the petitioner in WPC number so and so. The first one, huh? Hold one number so and so have registered and have been issued the Udhyam registration certificate, wherein it is categorically mentioned that the date of incorporation oblique registration of the enterprise was 7/8/2012, and the date of commencement of commercial production of the business is 8/2/2014. In the case of the writ petitioner in WPC number 5966/2023, the record should show that the said writ petitioner
Page 275.
But 2000 নহৰে ভুল আছে। 5966
5966. Page 275, Lord.
Huh?
Page 275.
was initially registered on first of all 595273/2023.
273, Lord.
The petitioner was initially registered under the Assam Preferential Store Purchase Act 1989 and was issued a registration certificate on 17/11/2009. The Entrepreneur Memorandum Part 2 was issued on 29/10/2009, wherein it was duly mentioned that the petitioner had commenced its activity from 22/10/2009 and further the registration certificate also stipulated mentioned that on 18/10/2009 is the date for registration of the enterprise. Where's the Udhyam certificate?
Page 61. Where is it?
Page
Page 61. 61.
61.
One SRK.
No, not the other one, the Udhyam. Udhyam certificate? 61, na?
61.
The Udhyam certificate which was issued in terms with the notification dated 26/6/2020 also records the date of registration of the petitioner as 18/10/2009 and the date of commencement of production as 22/10/2009. In the case of the writ petitioner in WBC number
5966. 5966.
5966/2023.
The term is at 275.
The petitioner was registered under the Assam Preferential Store Purchase Act 1989 and was issued a registration certificate on 19/12/2008. And further, the Entrepreneur Memorandum Part 2 was issued on 12/11/2008, acknowledging that the petitioner had commenced activity on and from 6/7/2002 in respect to PVC pipes and on 4/11/2004 in respect to ACP pipes. Further to that, the Udyog Aadhar Memorandum, it was duly mentioned about the petitioner's Entrepreneur Part 2, Entrepreneur Memorandum Part 2, and the date of registration. In the backdrop of the above, it is relevant to take note of that from the work orders which were issued to all the three petitioners, the details of which have been given in the charts detailing out the work orders and the date on which it was issued, it would be seen that all the three petitioners were registered under the Act of 2006 at the time when these work orders were issued. Under such circumstances, it is therefore the opinion of this court that the second reason so assigned, that it could not be ascertained, appears to suffer from malice in law and contrary to the appears to malice in law. In order to deprive the petitioner of their dues by whatever manner appears to suffers from malice in law and requires interference. Now let this court take note of the third reason so assigned. In all the three orders. The third reason so assigned is that it could not be ascertained if the petitioners in the batch of writ petition disclosed its status as MSME entity while the said order was allotted to it. Mrs. Hazarika, the learned senior counsel appearing on behalf of the petitioner, submits that it has been the policy of the state of Assam since 1989, which is followed by the procurement policy in the year 2015, that special incentives would be given to encourage the enterprises registered under the Act of 2006 as well as the Assam Preferential Act of 1989. The Learned Senior Council submitted. That the petitioner herein claims entitlement on the basis of a provision of law. That is section 16, 15, 16 and 17 of the Act of 2006. And the ignorance of law can be a no excuse. It is further submitted that there is no stipulation in the work orders that the work orders would not be issued to the enterprises registered under the Act of 2006. On the other hand, Mr. R. Gogoi, appearing on behalf of the respondents, had submitted that whether that issuance of work order upon the petitioners is one thing, but for payment of interest in terms with section 16, unless and until such disclosure is not made, the authorities cannot be said to have known that the petitioners were entities registered under the Act of 2006. And as such, and more particularly when the work orders did not stipulate that the works have been allotted to the petitioners, as the petitioners are enterprises registered under the Act of 2006. This court have duly perused the work orders which have been enclosed to the petition.
Page 57. And I'll just draw your lordship's attention to clause 7 payment.
Clause
7. Where it talks about ASIDC. Assam Small Scale Industries Development Corporation. Even in clause B, it's
means
means that
payment will be made after receipt of the materials in good condition and a thorough verification by the consignee subject to availability of fund. 5% commission of the ASIDC Limited, Guwahati, against the supply shall be paid directly to ASIDC by
paying authority. ASIDC is Assam Small Scale Industrial Development Corporation. So these are guided under them. And even if first bills in triplicate, this, manual tests are to be submitted through the ASIDC Limited for verification. In turn, submitted. So ASIDC is the nodal officer, one can say here, who will verify and then forward the bills.
This court have duly perused the work orders which have been issued to the three petitioners. From a perusal of these work orders, it is apparent that the supply orders were routed through the Assam Small Industries Development Corporation Limited. And because of that, a 5% commission have been paid to the said corporation. Madam, you have taken that in your pleadings also, na?
Yes,
Where is that statement?
no, that I may have not taken, Lordship, because that was never, this is only now. Neither in the affidavit.
No,
have
no,
said-
they have said about did not disclose when they became the MSME. How do you take care of that ground?
Lordship,
They have taken three grounds. First, MOU. Second, MSME or not could not be verified. Third, when they became an MOU, whether they disclosed or not.
yes.
So you must have taken care of that ground.
taken
How
care.
did you take care of that ground in your pleading?
Felt that the petitioner states.
Yeah, I will. You know,
Yes, Lordship. Yes, Lordship.
33.
We are reading
In, thing, 5 to 7.
5 to 7.
Submission of the petition.
Forty-six, I have said that I am MSME since inception.
Hmm?
36, I have said that I'm registered as MSME since inception and has been registered under the same while receiving supply orders. Seventeen. ইমান petition আছে ন, মই মানে পগলা হৈছো। We said that we are 17, we have said that registered under small scale and also under APSP. First under APSP, then under MSME. Then we have given a chart showing
Paragraph 38. 38.
You come to paragraph 33 of your petition of Kamaikha.
of Kamakha. Here, I think it's 38. Anyway, get up.
There is no reply.
33. Yes, I have said that. They have not replied to this matter.
In fact, it is also pertinent to mention that this aspect have been stated in their pleadings of the writ petitioner. However, the same have not been replied to. First, in this perspective, this court now finds relevant to take note of Section 16, 15 and 16 of the Act of 2006, which imposes an obligation upon the buyer to make payment and statutorily imposes an interest if the buyer fails to make payment within the time frame stipulated. Full stop. It being a statutory mandate, it is supposed that the respondents were well aware of the said provisions. The routing out these work orders through the Assam Industries, Small Industry, ASI, Small Industries Development Center,
Corporation.
the Development Corporation, also gives an indication that these work orders were meant for small industries only. Full stop. Considering the above, it is therefore the opinion of this court that the third ground on which third reasons so assigned cannot also be sustained in law. Full stop. Accordingly, this court, therefore, is of the opinion that the impugn order, as the grounds and reasons assigned in the impugn orders dated 27/4/2023, in all the three petitions cannot be sustained in law, the same is required to be interfered. First. Now let this court take up another aspect of the matter, wherein the plea pertaining to alternative and efficacious remedy have been taken by the respondent authorities. It is seen from a perusal of the affidavit in opposition that the respondent authorities have taken the plea that instead of exercise of powers under Article 2 to 6 of the Constitution, the petitioners are required to, petitioners or any aggrieved person having not been paid the amount in terms with Section 15 and 16, a reference can be made to the Micro and Small Enterprise Facilitation Council. And therefore, this writ petition ought not to be entertained. It is the opinion of this court that the said submission is misconceived, taking into account that the order dated 27/4/2023 questions the very entity of the petitioners as enterprises and registered under the Act of 2006. In the opinion of this court, this very aspect could not have been decided by the the Micro and Small Enterprises Facilitation Council. And therefore, the plea that there was an alternative and efficacious remedy cannot be applied. Be that as it may, it is also very pertinent to take note of Section 16 of the Act of 2006, which is reproduced, 15 and 16 of the Act of 2006, which is reproduced hereunder. Where is the judgment of the Calcutta? A perusal of the Section 15 of the Act of 2016 statutorily imposes a liability, a obligation upon the buyer to make payment on or before the date agreed upon between the buyer and the supplier in writing, or where there is no agreement in that behalf before the appointed date. The appointed date have been defined in Section 2B of the Act of 2006. Meaning, the day following immediately after the expiry of the period of 15 days from the date of acceptance or the date of deemed acceptance of any goods or any services by the buyer from a supplier. Footstep. Section 2B being relevant is reproduced hereunder. The proviso to Section 15 further stipulates that under no circumstances the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the date of acceptance or the day of deemed acceptance. This proviso is relevant, taking into account that irrespective of any agreement between the parties, this proviso holds the field and thereby confines the period not to exceed 45 days from the day of acceptance or the day of deemed acceptance. First. Now let this court take note of Section 16. There are two aspects of interest in Section 16. First, that it is to be calculated from the appointed date, and secondly, it would be compound interest with monthly rests. In this regard, this court finds it very relevant to take note of a judgment of the Calcutta High Court in the case of V.K. Patel and Co. versus Simplex Infrastructure Limited, reported in 2024 SCC Online Cal 6617, wherein the Calcutta High Court have explained the very concept as to how the calculation is to be made in terms with Section 16. paragraph 20 to paragraph 26 of the said judgment. Paragraph 20 to paragraph 20 paragraph 20 to paragraph 29 at the 31 being relevant is reproduced herein under. This court is of the opinion that the interpretations so given to section 16, this court opines that is this court. No, the interpretation so given to section 16 by the Calcutta High Court as quoted herein above appears to be on correct principles. And this court duly agrees to the same. In the backdrop of the above, therefore, it would be seen that the petitioner herein would be entitled to the benefits under section 15, 16, and 17 of the Act of 2006. But what would be the benefit? I mean, how the interest is to be computed cannot be ascertained by this court, taking into account that the materials before this court is only refers to the work orders. And the date on which these work orders were issued. There are questions of facts pertain to as to when the work supplies were made. Semicolon. The supplies were duly accepted. Semicolon. Whether it was accepted or it was a deemed acceptance. Semicolon. What is the rate stipulated by the RBI during that period? Taking into account that the rates are to be, the interest payable is to be compounded with monthly risks. Accordingly, this court therefore disposes of the instant writ petition with the following batch of writ petitions with the following observations and directions. The impugned order dated 27/4/2023 in the case of so and so, এখন writ petitioner, is set aside and quashed. Number 2, set aside and quashed. Number 3, in writ petition, set aside and quashed. Number 4, the petitioners herein being enterprises duly registered under the Act of 2006 would be entitled to the benefit of section 15, 16, and 17 of the Act of 2006 in respect to the work orders, which is the subject matter of the present petition. Number 3. The petitioners herein are directed to, are given the liberty to make necessary calculations in terms with Section 16 of the Act of 2025, 2006, and the interpretations so given by the Calcutta High Court in the above quoted paragraphs, and submit the details within, and submit such details, making claims before the commissioner. Additional? Huh?
Chief engineer niki?
No, don't give this. These are very difficult people.
Special Chief Secretary.
Special-
Special Chief Secretary.
Yeah.
Ah,
Even-
so
even
give
more-
it to him better.
Even, but
Huh?
even more difficult. Very busy man.
No, if he is given, then it things will happen. The special secretary and so and so. Post. Upon submission, how much time?
We can do it, Lordship, 2 weeks.
Mrs. M. Hazarika, the learned senior counsel, submits on instructions that the petitioner would do so within a period of 2 weeks. Number 3. Upon submission of the said details, the Special Chief Secretary to the Government of Assam's PHE department shall make verification only to the extent as to whether the claims as regards the claims made in terms with Section 16 is as per the mandate stated herein above. Full stop. The petitioners next. The petitioner and the same, and thereupon within 90 days,
90 days.
within 90 days, make the payment if the calculations were found, and within 90 days, the payments be made to the petitioner. It is observed that in the circumstance, the Special Secretary to the Government of Assam PHA department is of the opinion that the calculation is not in terms with Section 16. It would lead to a dispute, and both parties would be at liberty to approach the MSME so and so.
We can make the necessary, the department can make the necessary.
No, I cannot do that because you are again coming back here. I'm not going to make that. No, madam. Next. Number 5. The last. This court further observes that the payments so made during the pendency of the instant writ petition
And before.
shall be deemed as payment made of a part of the claim of the petitioner
Yes.
and not payment of the principal, as there is no apportionment done. And as there is no directions passed for apportionment.
But better if we had made the correction.
No,
itself.
no. Otherwise, again, I have to calculate. And madam, there is another thing. It would lead to floodgates if I do that. I thought about it because if I do it, once I do it, everybody will come here.
Lordship,
Nobody is
it'll
going
teach-
to go there.
It'll teach the government a lesson.
Hmm?
It'll teach the government a lesson
Which one?
to make early payments.
No, this order will help you. Now, if you want to negotiate, you do. That is out there. I should not mention anything because I have delayed on this. Where is the affidavit filed here?
Affidavit has been filed.
Mr. Panging, tell me, do you want to proceed with the matter or not? Yes, can you hear me, Mr. Panging? I can't hear you.
Am I audible, my lord?
Yes, now clear.
Yes. My lord, I have instructions to withdraw the writ petition, my lord,
Yes.
with liberty to, my lord, challenge the clarification at the 3rd of March, 2022.
And then next time when you file different writ petitions, not one. Because everybody's interest is being, there is a conflict
Yes, yes,
of the
yes,
petition number 1 to 4, because
My
who
lord.
will become the Seristadar?
My
This
lord, I've
other
got.
thing will give up. Secondly,
Yes, yes.
otherwise they have a right to, in terms with this, they can very well go ahead and do, become the Seristadar of that particular place.
Yes.
And secondly,
My lord,
this
basically the
particular
writ
petitioner
petition,
number 1 may not like to go to West Cumming.
maybe, my lord.
Yes.
But basically, in the writ petition, my case was that, my lord, since it was done centrally, at least for these candidates, my lord, some schemes would be
Yeah.
there for the High Court. That was
Okay,
my
that
case.
is it. You have done some social service, take it. Now let me take it up with the government, the High Court. How do they do this? Yes.
Well,
How do you, by way of a letter, change the rules? The rules do not say that it would be district wise. Does it say?
My lord, Rule 6, my lord.
What does it say? Rules.
Rule 22, sub-rule 6.
Huh?
Yes.
Rule?
At page 59 of the writ petition, my lord.
What does it say?
Rule 22, seniority, sub-rule 6, every year in the month of January, seniority list of officers in all cadres shall be prepared and published by the appointing authority.
Hmm.
So accordingly, my lord, appointing authority here, my lord,
Then the entire selection will go.
the stand of the High
Hmm.
Court is this.
No, no.
Yes.
My question is, you have to therefore make it very clear by way of an, if you want to interpret 22(6) in this manner, you have to issue a executive instruction. Don't you think so?
Very
Yes, Mr. Monto. You are the senior counsel out here, or senior standing counsel, whatever it is. Is it possible by way of a letter? What has happened here? Prior to the rules coming into force,
my lord.
following Renew, a centralized recruitment was done. Advertisement was issued. These people were appointed post the rules. And the appointment also at that point of time was not appointment order, it's later, but select list was done by the centralized, which is not what is conceived under the rules. Whereas the High Court also provided who would be the appointing authority for these people. The appointing authorities have been mentioned to be that person out there, the district judge of UPA. For all these persons. Now, the rules do not specifically say that the cadre would be in that manner. It says appointing authority. The appointing authority are two. It may be the High Court for administrative officer or any other officers, or where the High Court specifies anybody else. Now the High Court has specified as the particular district judge of that, not for these particular district judges. Understand?
Yes.
So therefore the problem arises later on. Now what has happened? A particular communication has been issued that look here, this should be done as district wise. Thereby, the person who was 9th or 10th in the select list, in view of his seniority in West Cumming, he becomes the Seristadar. The petitioner out here are in other district establishments, in the various other district establishments. They have not got the chance. They say that this was done centrally. Everything was done centrally. So So the moment the High Court now says that we rely on the appointing authority on this aspect without a clarification by way of an office memorandum, it cannot be by way of a letter. It has
That letter issued under what authority?
raise the vigilance rights to the register of that particular. That cannot happen in that
Not-
manner.
235?
No.
Then my lord, here that is simply a letter.
It's a simple letter by which how
Yeah.
are you tweaking with the rules? Because the rules under 235 are made by the state.
State.
So when the state make the rules, you are tweaking the rules and making it the cadre to be out there in district wise.
Equipment was made separate.
Central. So this will have a lot of complications later on.
Exactly. Now, but here in this case, probably I've seen that he's withdrawn. Well, I take that, my lord. In this case, my lord, probably there
Now
is-
he also, Mr. Panging withdrew. There's a reason why. He thought that I should be given the Sejtadar and he will be given the Sejtadar in his place. Isn't it, Mr. Panging?
Yes, yes, ma'am.
now I think a better decision.
He thought that he will give in, but he doesn't want the Sejtadar to be in West Kamang on account of the cold and the bitter cold out there. So he's more happy out there in UPA. So that is why he's withdrawing. And more particularly, there is a conflict of 1, 2, 3, 4. If he's asking for this as a centralized, the first one may become the Sejtadar, others may not. So that is why he is asking for that. So that is why he is withdrawing it. But this letter has a lot of problems. So you have to advise that the register,
My lord,
yeah, on the administrative side, the Guwahati High Court should look into that.
my lord, in administrative.
This is something very serious. And with this, the petitioner is good. The petition number 1 is also good. Now in UPI, he will become the Sejtadar
He's happy.
whenever his chance comes, without any objection from petition number 2, who is in some other place. Okay, heard Mr. D. Panging, the learned counsel, appearing on behalf of the petitioner, Mr. Muk Patin, the learned senior counsel, assisted by Mr.
Okay.
M.B. Patin. The learned counsel appears on behalf of the respondent number 3 to 10. Mr. G. Busher appears for the respondent number 1 and 2.
Yeah.
And Mr. R.
Oh,
L.
we did,
Kuban, the learned counsel, appears on behalf of the respondent number 11. Pursuant to the directions passed by this court on 6/11/2025, the respondent numbers 1, 2, and 3 have filed a consolidated affidavit. Full stop. Be that as it may, the counsel appearing on behalf of the petitioner submits that the the petitioners have instructed for withdrawal of the instant writ petition. In that view of the matter, the writ petition therefore stands closed on withdrawal.
My lord, liberty, man.
No liberty.
Just
What
in case.
liberty business?
Oh, may I put to challenge
your
that
fight was
communication?
against respond number 11. What liberty?
Yes, that is there.
No liberty against respond number 11 unless you challenge that particular letter. If you want to
That,
challenge,
that is why, my lord.
you want to challenge
Yes,
that.
yes, ma'am. Yes, my
So
lord. We will
Mr.
see,
D.
my lord.
Panging, the learned counsel submits that he would like to, the petitioner, however, would like to challenge the communication dated. What is the date of the communication?
3/3/2022.
3/3/2022. Full stop. Liberty, however, is given to the petitioners to assail the same.
Oh, my lord.
Also advised.
My lord.
Where is Mr. Hawk? What is this side visit?
Right.
You have changed your loyalty from that person now. What is his name?
Your person,
Huh?
your person.
Zial Pasa? Now we have Deepak Sharma also coming in.
My lord,
And another is there. Another person.
10 hours.
Huh?
10 hours.
Yes. What is this? Site visit.
There was a witness, this is a site,
Publishing 2210.
they have
Bid
submitted
submission 1111.
7/11, my lord,
Now where is that? Your clause is which clause?
close 7.
7.
Yes.
7.1.
Yes.
Okay. Then, when did you visit?
Method, it method, method, page number.
On
Page
311.
142.
I would
Definitely.
like to inform you that I want to participate in the tender dated so and so. So kindly visit me, issue me the site visit for a year. Then, where for site visit?
Yes.
I visited the site on 7/11 of the proposed so and so under your division, so please kindly issue me that. How many different, or is it the same?
Method. Yes, ma'am.
Same.
Yes.
3 and 11 are same. So these are photographs.
Method,
143 are the photographs.
Yes.
And this is Deepak Sharma.
book down. That is. It is against the package number 1. That is DNA.
So you have submitted the bid
Yes, sir.
on 11th.
Yes.
But without the site visit because it was not given.
Not.
Technical qualification done.
No.
You issue that site visit certificate. Site visit certificate.
The director that for this ground, technical bit, it not be rejected. That's the case. Might be some reason.
Issue notice making it returnable on
Method, in fact, 145.
no motion business. I don't disturb anybody. Issue notice making it returnable on on 19th of November 2025. Mr. B. Gugoi, the Standing Council of the PWD Department accepts notice on behalf of the respondent numbers 1, 2, and 3. Some extra copies of the petition be served upon him during the course of the day.
I have already have.
Extra copies means different, huh?
Method, sorry.
Pursuant to a notice inviting tender dated 17/10/2025, the petitioner participated in the said tender process. The petitioner. Pursuant to the notice inviting tender dated 17/10/2025. In respect to two works, Mr. Hawk, in which work you are interested?
I am package number 1, ma'am. Here, 48.
Notice inviting tender dated. The petitioner is interested in respect to the package at serial number 1,
Right.
which relates to a work to Namtu Lekhi Depot 1. In terms with clause 7.1 of the said tender documents, there is a requirement for the bidder to visit the site and also thereupon submit a certificate issued by the executive engineer concerned, that is the respondent number 3. The petitioner visited the site on
711.
7/11/2025. And who is the other person? Who is the next person? There are two persons out there.
Method, it's not, not some other method. It is not mentioned in the method.
On 7/11/2025. And made a request to the respondent number 3 by the communication dated 7 of the same date to provide the site visit certificate in respect to the work in question. in respect to the work in question. However, the site visit certificate was not provided to the petitioner. Be that as it may, the petitioner submitted the tender on 11/11/2025, submitted his bid on 11/11/2025, as it was the last date for submission of the bid. The petitioner apprehends that on account of non-submission of the site visit certificate, which the respondent number 3, for reasons best known, did not issue, the petitioner would be technically disqualified, for which the petitioner has approached this court. Mr. B. Gogoi, the learned counsel appearing on behalf of the standing counsel appearing on behalf of the respondent, submits that he would obtain instructions as to why the site visit certificate have not been issued. So this court, upon hearing the parties and there being an serious apprehension in the mind of the petitioner that the petitioner's bid would be rejected on the ground that the site visit certificate have not been enclosed, is of the opinion that the petitioner herein is entitled to certain interim directions. Accordingly, this court therefore directs that till the next date, the petitioner's bid in respect to package number 1 of the notice inviting tender dated 17/10/2025, which was submitted on 11/11/2025, should not be rejected on the ground of non-furnishing of the site visit certificate. This court, however, have not debarred the respondents to consider the bid of the petitioner as well as other bidders technically on the technical aspect on any other grounds.
Item number 3, same by the
What?
item number 3. And the matter only
You have sought for permission of one.
but it's too much.
Never.
That is package number
Itu package 2 only.
parking ticket. I am DP of place.
Yes, what has happened?
Main piece of the lordship, the owner is a lessee of a showroom measuring about 26,500 square feet.
What?
The petitioner here is a lessee of the
How
property.
does it matter if it's a lady or a male?
He is a lessee of a property.
Or lessee?
It's a property owned by respondent number 529.
Hmm.
And under the lease agreement,
Hmm.
I have a right to construct, I have a right to peaceful occupation, as well as use the property for business purposes and also to sub. And it is my obligation to pay the electricity. So from 2016, I have been enjoying the property. In the year 2020, I have sublet the property as I am permitted under the agreement. Now, what has happened? And the sublet has been also been operating till today, means still. But the respondent number 7, who is one of the co-owner, gave a complaint to the APDCL and requested for permanent disconnection of the electricity.
Hmm.
And on the basis of that, the APDCL disconnected the electricity connection. After that, I approached the civil court for mandatory injunction for restoration of the previous connection, as well as a miscase was filed for exemption of 82, which was allowed, and also another miscase for injunction under Order 39. Now, without hearing, the trial court didn't pass an injunction because they were to hear the government advocate. On 10/11, the government advocate appeared. However, no injunction was granted because they took time. Now, in that scenario, Lordship, I have approached before this honorable court because I need restoration. Now I want to apply for a temporary connection because this process is taking time. The restoration is taking time. I want to apply for a temporary connection, but the only impediment is that under the rules, I have to get the NOC from the owner, which the owner will not give. So, and this is affecting my right to livelihood and also my right to shelter life. So I am approaching that the NOC should be dispensed
But
with.
why have you not filed a division before under section 2, article?
That I could have, but
That should have
Yeah.
been taking into account. You are not asking for the permanently connection to
Yes.
the whatever maybe is you are asking for a mandatory injunction. So
Yes.
there might be an interim mandatory injunction asked for. Why have you asked that? Because wouldn't this be a multiplicity of proceedings? Yeah.
here,
You see, the moment I pass an order here, it would be in effect that order itself touching on that civil suit. You should have immediately directly first approached this court itself. If you
Yes, that-
wanted that.
yes, that.
But having moved the civil court and done all these things, how can I help? Yes, Mr. Pathak.
The way is that matter, I believe it. Very clear on the thing. You can try. The proceeding before the court below, that on the thing. So, perhaps my unaffected side. The prayers as they have been structured in this position, there's no prayer for the prayers in my but that thing.
Restore the previous. See, it's the same relief.
No, yes,
See, paragraph 3.
page
The
20 of-
interim is temporary electricity. Page 22, paragraph clause
Yes,
3.
22, restore the temporary electricity.
No. 3.
To restore temporary electricity connection.
No. 3. A writ in the nature of mandamus shall not be issued directing the respondent to restore the previous electricity.
This I will not press for, I'll only press for one euro.
No. It should have been your main relief.
Yes, I.
Then-
But Lordship now,
It doesn't appear now bona fide.
the Lordship on 26 also, this is a bit.
Withdraw suit, come back. Again. That is the only way. Withdraw suit and ask for them. Have you asked for temporary for them?
Because they will insist for.
Have
NOC.
you asked them they kindly provide me the temporary connection?
That they have not done because without
Then
that,
why are you demanding justice?
that NOC, your Lord. Then-
No demand for justice.
I understand, but without the
Justice
NOC, I
has to
would
be-
be step.
And you have given a false statement here. It's a false statement on. The petitioners have aware that demanded justice. You are asking for a writ. No, that statement is also not there. Yeah. Statement is also not there. How can I issue a mandamus?
That's considered it's. But in a similar situation
Which one?
of our High Court,
With our High Court. I'm not going to listen to.
What?
Where did you demand justice?
I'm,
Without demanding justice, how can I issue a mandamus?
here I'm only requesting for dispensing the NOC. Then I will.
That I can do many things. But think, why should I? Taking into account your conduct. Truth is pending. Truth, the same relief is being sought out here. And now you are asking for a temporary connection without asking them. Go and approach them and again come back. We'll have it on Monday, Tuesday again. Or if you approach them, you will consider. Isn't it, Mr. Pathak? Ask for the temporary connection from them. 48.
4.5,
4.5 apply and then come back.
but they will insist then.
Huh?
They will insist for that NOC.
Understood. They will insist for the NSC, then I will come back with that application. Then you come back, file another petition. Then, obviously, again, motion unlisted, permission given on Tuesday, we'll get. But first do that. Because, Mr. Sharma, there is a problem. What relief you are asking is the exact relief which is there in the suit. This court cannot go into that. If you want, therefore, you have to ask for that. Kindly give me the temporary connection pending the suit. It's not your relief. This is how you approach. You don't come up with this. You don't file this appeal like this. Withdraw with liberty to approach them. and they shall consider. And if not, again approach. That is the only order. You are a lessee of 26,000. You are not affected. Are you an affected?
My sub-TC is not affected. My sub-TC, I have,
So he has not come.
that I have been pressurized.
Understood, but he also has not come, he or she. Who is affected? You see, if you bring in the judgment of Dilip death, for whom it is essential? Not Sweta Jala, yeah, who is. It is for the sublet. Yeah? What is it?
It has to be put by that person.
Ah, so that sublet has to be given. You give the NOC. You have a right. Give your NOC to him and ask him to apply for the temporary. They cannot ask for the owner because you have a right on the basis of a registered document. Why are you not doing that? You are on that NOC. NOC is not from the owner.
It is from the,
There is a registered document most probably.
Yes.
Because you are claiming on the basis of a
Mm.
right.
Yes.
So you are a lessee. You are not a tenant.
Right.
You are a lessee, proper lessee. Where you have a right to construct, you have a right to do many things. So this is a registered document for a particular period of year. So therefore, you become the owner. So you give the NOC to your sublessee, ask the sublessee to apply. They will give. Isn't it, Mr. Pat? Yeah. Withdraw. Otherwise dismissed
Yes,
with
I will-
cost.
no, I am withdrawing, but it kind
No.
of to make that observation.
Enough of legal advice given here. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant petition. Rather, the sublessee would apply for a temporary connection and before the FPDT. And if such permission is not, no temporary connection is granted, the petitioner, the sublessee would do the needful or even approach the spot. Taking into account the above, the instant petition stands closed on withdrawal. It's the liberty given to the sublessee to approach the judicial authority for temporary connection, if so advised.
Obliged.
I take 12, that two. You give the NOC. Motion's finished. Yes, what is this?
Well, that's
Oh,
the
blacklisting. Blacklisting, I can't do it. I have to rise early.
Well, the, here, on one point itself, my lord, Mr. Lordship, my learned friend has submitted the entire agreement. As part of, my lord, the manager is not authorized matter. Only managing director is authorized.
To blacklist.
All the public. Your lordship see, my lord, one page, my lord, only.
Mr. Sayola,
Yes.
I'll be rising early
That's correct.
today. Is there any urgent matters for anybody? Then I can take it up. I'll rise at 3. Your matter urgent? Is it urgent? So the urgency is not of such grave nature.
Well,
Yours
a
is
fixed date may be given, my lord.
obviously we'll fix it next week Tuesday. We'll fix it. Next Tuesday. Okay. He has urgency, na? So let us finish off his. It's a small matter. Yesterday I heard that. 2 minutes, please. And if time permits, wait till 3 o'clock. 2:45, if I can finish his matter, I'll take up your matter. Okay, let me take up his matter first. And Mr. Nair, your matter pertains to that labor court, huh?
Yes.
Anything from the government?
Filed an affidavit, the ministry had filed an affidavit, my lord. Saying that because if the ROP has to be followed. I have come across two documents to deference, one of the Supreme Court and of the High Court. In that, courts and industrial type, they come within the ambit of, they come
High Court.
of district. One of the
Yes, please give me that judgment, then it makes it very clear for me. I was on a different notion of together. You got judgment to side.
Supreme Court had relied on some other judgments as well. 1998 SCC 6A. State of Maharashtra versus State of Okay.
If this is so, then in view of that Gujar's judgment, there's another judgment of Gujar. You find it in another case where dealt with, in that Arunachal matter, I dealt with that judgment, wherein it says, following a full bench judgment of a Madhya Pradesh High Court, that if the judges are there, are to be brought within the ambit of 235 and 236, then the staff will also come within it. And if that be so, if this is the principle to be followed of 98 to SCC, then the staff will also come in view of that judgment. Have a look at this. Again, or something like that. It's reported judgment. I think it is in the last JLT you may find. Last. So, there it was matter went from a full bench of the Madhya Pradesh High Court, na? Yes. Where the last, I think the last two penultimate paragraph, the Supreme Court says that the judgment of the Madhya Pradesh High Court is right to hold that the ministerial staff will also come in. So if that be so, with that and this, then obviously he is entitled for that because he has to be parametrially taken into account. Necessary, just bring in some additional pleadings if necessary. Then it will have more clarity in the aspect because anyways the finance have not bothered to file any affidavit. So have they filed? What do they say?
They say they have to follow the ROP.
ROP, no ROP business out. ROP you follow, but in taking into account that they are follow ROP as per the what you call the judicial department, not as the labor department. Mr. Barpujari, you look into this judgment. State of Maharashtra versus Labor Law Practitioners Association and others, 1998 to SCC 688, as well as that Gujar judgment. You have a look at that. So with that, we will hear you next Thursday on this very interesting point. The Supreme Court has said it is okay for me, but although I still defer to hold it, it becomes very difficult to hold it because of the fact that Section 7 is different. Whereas Section 7 was taken into consideration at all.
And also a Kerala.
Industrial Section 7 was taken. Section 7, how do they take it? Anyways, let me take up the other matter where there is no urgency. List this matter on next week. We finish up this one on 20/11/2025 for further hearing.
Deep here. Highly
Yes, what is your case?
Present petitioners, Lord.
Your junior yesterday surrendered it and said they kindly dismiss my petition. I said to let your senior come to dismiss. I like to dismiss it in his hands.
There are six petitioners,
Huh?
seven petitioners before your lordship. Seven petitioners before your lordship. They are dealing in vegetable business in Longka, municipal board. They have been running their business since 2015, someone is 2010. And in the year 2022, the board came up for a new project that they are going to construct a Paka house on that. According to petitioners allowed, and they are assured that as soon as Paka construction is completed, they would be accommodated party.
Where is that?
They are issued, this is not written lawsuit, they have issued
Minute?
resolution.
Minutes?
Minor lawsuit, not with that lawsuit, they have
No,
filed
there cannot be verbal resolution.
lawsuit. So kindly allow me. So they have filed this affidavit on opposition lawsuit in the light of that resolution, but they have not annexed the resolution. So
Have
not
they
seen.
stated in the affidavit in opposition that there
Now,
is
that's
something
not
to the
mentioned.
effect?
Our plea is not mentioned, lawsuit.
No, Mr. Counsel, have they mentioned in the affidavit in
No,
opposition
no.
about the resolution? No. Then,
They have mentioned resolution,
then,
but our part
the,
is not.
Mr. Counsel, civil court may help you out, not I. I can't help you out because of the fact that unless there are two types of trade licenses issued by Lanka to type 1, type 2, so and so. As per your Lanka, Mr. Counsel, one committee of so and so, so and so, so and so. With the position, the number 10 subsequently contained the donor for construction of room for the hostel so and so. The response to the notificated applicant applied for data so and so. The you only petition number 1 applied.
Applied.
Others
In
did not.
Format lawsuit petition number 1 applied, but other petitioners lawsuit applied and sought for allotment lawsuit, but in not proper format.
No matter
Before issuing the input notice,
why didn't you apply properly?
that is not kept the lawsuit resolution. They have not kept the applications lawsuit because since it was they have applied.
Is it
applied.
your case that the petitioners all applied?
Yes, lawsuit applied, but is not proper format.
Where is it?
So that
Where is your statement made in your petition that all the petitioners applied?
not applied lawsuit. Lawsuit, we have mentioned we have approached. Yes, lawsuit. I understand. Lawsuit.
They gave it as per the lottery.
Yes.
Now, anybody, people have now got it. If you want to challenge this, there are two options. Either you have to make those people a party, one, or the second challenge is that you have not been given out there. And as such, the consideration is wrong without taking your application. But they say that your application was duly made, only petition number 1 submitted, others did not. You have not submitted a reply also to that effect. But anyways, the fact remains that the other petitioners did not apply properly or there is no even statement. And if you therefore say that there was an application filed by the petition number 1, then also you give up of the resolution earlier. Meaning thereby you have applied to the lottery. You may not get it, it's a different thing, but you applied.
I have been informed that lottery was they have
Huh?
hold lottery secret. That was not publicly hold lottery.
And what they apply, they mentioned that one.
Therefore, the problem is don't file so many petitioners together.
Yes.
The petitioner number one knows. Other petitioner doesn't know. How is it possible?
They mentioned that in their affidavit petitioner number.
Forget
one.
about them. I am saying about if petition number one knows, how the other petitioner doesn't know. You should have filed the petition number 2 to 6 or whatever may be separately. But filing all together have made the problem. So with the petition number one knowing, it will be deemed the others also know. Are you not sailing in the same boat?
At this stage, Lordship, I am praying for Lordship, let them produce all the resolutions as well as the selected candidates, Lordship, those who have Lordship, Lordship.
Why?
In resolution, Lordship, it may have mentioned, Lordship,
What?
unconditionally, as soon as Lordship construction will be completed.
So
we
you
do the
say that the
recommendation.
resolution which was taken when?
So many resolutions they have mentioned, Lordship. but
On
they have
2/9/2023 or when? Which resolution? 15/7/2022.
Yes, Lordship, and another one is 25/8/22. They have mentioned both these resolution is required.
So you say that as per these two resolution, it was recorded that you will be given some preference.
Perhaps, Lordship, I'm not sure.
No
As
preference.
per my
There is a term called fishing and roving inquiry. And this court is not for that.
and allow them to party the resolutions part.
Why?
We have gone.
Mr. Nath, what about these resolutions of 15/7/2022 and 25/8/2022? Do you have a copies of those? I'm not on that. Whether how is the lottery, he is not challenged. I'm not concerned with that. But the question is whether there was a resolution taken on 15/7/2022 or 25/8/2022 that some preferential treatment would be given to those persons who were earlier holding, residing, carrying on business. So you have mentioned about two resolutions. Mr. Nath, I understand. There are two resolutions. You have mentioned in paragraph number 5, isn't it? The counsel for a petitioner makes emphasis on paragraph number 5, these two resolutions, where the resolutions on the basis of which some preferential treatment was to be given to the petitioner. He makes a statement out here that they have mentioned about this resolution but not enforced the resolution. Let us have a look. The justice also needs to be seen to be done. Have a look at it, whether it is there. Otherwise, you don't have a case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. D. Nath, the learned counsel appearing on behalf of the respondent. The learned counsel appearing on behalf of the petitioner specifically submitted that the grievance of the petitioner is on account of certain resolutions which were passed, the details which have been passed on 15/7/2022 and 28/5/2022, wherein it was decided that those persons who were already carrying on the business would be given certain preferential treatment, as they would have to vacate that area for the construction of the building. He therefore submits that the petitioner would not insist on any other ground except the fact that the preferential treatment which was promised, for which the petitioners vacated for the purpose of construction of the building, have been negated by the actions of the respondents. Mr. D. Nath, you have it? Where is that? Show me. Show him the resolutions. Read it if you find anything. Those two resolutions. Taking into account the say, Mr. Dinath, the learned counsel submits that he has copies of the said resolution dated 15/7/2022 and 25/8/2022. Provide him a copy. Copies of the said two resolutions be provided to the learned counsel appearing on behalf of the petitioner, so that he can petitioner list this matter again on 18th of November 2025 at 2 p.m. for final disposal. Give it to him, he'll give you a photocopy. He took it. Yes, Mr. Saiwala. Huh? Yes, 10 minutes. 18. What is this? What is your case? The matter in the matter pertains to the case of blacklisting. Where's the blacklisting order?
My lord, at page 105.
Yes. Greater public and patient interest your company so and so is hereby blacklisted and debarred from participation in any tender for 3 years as per the referred clause number 5 so and so. You are issued notice.
The notice has been given for Kotak Group. And the written by my lord is that dispose of the appeal, my lord, set of the.
Where is the notice?
That is the notice is.
Huh? Hence, in greater only you are asking for the not be debarred and the record present. So the notice is given.
Notice is given for Kotak, my lord, page 98, last paragraph.
No, kindly come to page 97.
Yes.
The last paragraph. So
Last
notice has
paragraph,
been
my lord,
given.
that provision has been quoted.
No, hence
My
in the
lord.
greater public interest, you
My lord.
are asked to show cause why your product should not be
but-
debarred as per the referred to and
Penal
so
clause,
and so,
these
so
penal
and so.
clauses are mentioned, madam.
Yes,
Only plain concern, but
for
that
5 years from the date of debarment and in case the manufacturer so and so. Then entire quantity of forfeiture and so and so. Please note that due to non-supply of so and so alternative will be debit as per so and so. Alternative purchase. So you are therefore asked to show cause why your product should not be debarred as per the referred so and so. Hence submit here. Then you submit your reply.
yes, my lord, we submit the reply. I will say that we are, my lord.
So the
products
notice
are
was
here,
issued,
my lord.
notice was issued by whom?
Notice issued by managing director.
Managing director. And the reply was given by, and you gave the reply where?
At page 101, my lord. They say the goods are lying at Guwahati.
Okay. So this is the, and your reply, and they have passed the order by the general manager.
General manager,
So you are asking, questioning the jurisdiction.
my lord. And my lord, as per agreement, it's the managing director who can only pass the order.
Where?
At page 440, my lord.
Huh?
Additional evidence page 440.
440.
Yes.
Oh my goodness, it will become so big. all notice of AR relating to or arising out of the agreement or any of that shall be
Right.
duly served.
Right.
Thereby declared anything. So you are therefore saying that the decision of the managing director is final,
And
but
from-
here it was decided by the general manager.
Yes.
And the general manager also do not say that it has been done under the aegis
Yes.
of the managing director.
No, some letters are there which are saying that the
There's a report to my final view, there is no affidavit. That matter, as part the delegation of power by the MP. Here, matter is now, but he has been authorized. Matter, if it's there, if it's not there, of course, he has no say. So it has to be there, not everybody. Yeah.
But whether the decision, whether the managing director could have overridden clause 8, wherein said the decision in the matter shall be final and binding. So it is the decision of the managing director.
That is the party. The head of the head manager will issue the matter to order. But the decision will be there in the report. It's not matter that matter with the FD will have.
No, the MD has issued the show cause. MD has issued the show cause.
Development order, but it will have to be approved by the FD. Something will be there that approved.
So have you mentioned when did the MD delegate?
Yes, yes, that part of.
No, where is that in your affidavit?
Yes, it is there.
it is only said
Huh?
Even from the government in the department, it is
No, the government cannot.
page one.
Who is authorized?
The MP.
Huh? No, no, kindly see paragraph 15. The so-called notice to the petitioner was issued by the managing director MSL and upon due approval from the M of so and the aforesaid requirement was issued by the general manager who is authorized and approved for representing the but this particular document is what?
it's the agreement.
If this agreement says that yeah, how can you change that yeah?
Even of the decision will have to go there. Whoever says that matter any order should be issued by the matter them. It is the benefit matter. There is the fight. We control the approach. Not that matter. All the time it is the communal secretary of the department will issue the order. It is matter.
No, no, no. We are not concerned with the commissioner secretary doing it. But we are only concerned with when the the contract only says that. Now kindly say, please be noted so and so, so and so, so and so. You are hereby asked to so forth.
The report and the NPS for the approach. That of course, but he may have on this point.
Earlier letters have been issued to the approval of the MP. That is
Speaker public input. So the MD must have written an order.
That's why. authorizing the managing director, the general manager, the my lord, department, finance department officer. But my lord, the
No,
decision will
it
be on
is
the
a-
MD.
no, you may say that this is the communication, not the order. So there is another order.
Something is the my lord, file, otherwise my lord, that's why I'm saying. The record is on it.
My lord, your lordship will just see, my lord, page 173. At page 134, my lord. It is issued by general manager. At page 174, this letter is issued as per approval of the managing director. Similarly, there at page 176, 180.
No, we may construe this to be just a communication, not the order. Mr. Gogoi, we will construe this to be a communication, but not the order.
Because by the last line of the in order, order is for trigger of the time.
So therefore, this will be an communication for intimate, but not the order. So the order has to be by the managing director. Let them produce the managing director. So let me record his submission that this is a communication, but not the order. Order has to be passed by the. No, no, it is the communication only. You have to be clear after filing affidavit, additional affidavit, you are yet to be clear as to whether this is a communication or an order. If it is a communication, it's okay. The general manager can give the communication. But the order has to be passed by the managing director. Ah. So therefore, this will be construed as a communication. Not the general manager have been empowered to decide. Because this goes against, what you are saying goes against paragraph number 13 of your affidavit. Paragraph 13 of the affidavit says that AMCL have authorized the general manager to act on behalf of the managing director.
Now, if he takes a decision, my lord, of course,
So therefore, that paragraph number 13 is different from what you are saying here in respect to this.
saying a communication, it is the order, that's why I'm saying the record is the order, that's not a communication. That's a petition against the benefit.
No, only the thing is what this court is going to do is, if it is not there, we set aside this. And thereby directing you to decide, giving a hearing to him and decide what the fee be. Court is not going to delay and keep this matter for long. This is a 2025 early part. We have to finish it up. I don't have the time, otherwise I would have. Anyway. This court heard this matter at length. And the question which arises for consideration is as to whether the general manager, procurement, QC, IT, logistics, Assam Medical Services Corporation Limited had the authority to issue the impugned communication dated 10/3/2025, whereby the petitioner was blacklisted. More particularly, in view of clause 8 of the agreement, which categorically mentions that it is the decision of the managing director AMSCL which will be of the matter shall be final and binding. Mr. B. Gogoi, the learned standing counsel of the health department, submits that he will produce the records positively on 18th of November 2025 to this matter on 18th at 2 p.m. for further consideration.
But
15 minutes it was done. Would have been finished.